We're going to get started. Again, we're recording today. I'm so glad to be here again with Jordan Ostroff, who is the owner of Jordan Law in Florida, and then also LegalEase Marketing, which is a law firm marketing agency. So Jordan, welcome. Glad to have you here.
Thank you for having me. I do love horror movies. Dark Sky is my favorite one. It's on Netflix right now. Great alien horror movie. Highly recommend it.
Thank you very much for that recommendation. I just watched a sort of creepy thing on Netflix called Nightcrawler with Jake Gyllenhaal. So that's not a horror movie. It's just a sort of strange character movie, if anyone's looking for other entertainment besides horror. But anyway, on the non-horror side of things, how to make your contracts not something that keeps you up at night like a horror movie. There we go. There's a sequitur.
Good lead-in.
So, thank you. So, we're going to be talking about whether you're starting a business or, you've been in business for a little while and these are sort of the nagging things that you need to get in order. Jordan's got a presentation here for you today, and we're going to discuss those 5 contracts, those 5 key documents that every small business owner needs. So, Jordan, take it away.
All right. For those of you who don't know me, my name's Jordan Ostroff, and I have the best job because basically I don't have to do anything that I don't want to do anymore. And I mean that it's totally a brag, but it also is a lot of hard work, and we'll get into a lot of those things in this through having the right agreements. But my biggest thing over the last couple of weeks is I got back from a week and a half vacation, and my office told me I could have been away longer, but they were totally fine without me. So I am unessential because of a lot of the documents that we will talk about today. So if you are an attorney who is, stuck in your business, or a business owner who's stuck in your business, these 5 things will get you on the path towards running a company as opposed to having a job. Oh, there we go. All right, so, oops. Sorry, my Zoom screen is messing up my screen share. So look, starting a business, exciting. I was a prosecutor before I opened up a business law and personal injury firm here in Orlando, and I can tell you the lows are lower. It sucks when you have those months where nobody's calling, but the highs are so much higher. You're getting into a huge obligation, and so today we're going to go over those documents that you need at the beginning. If you don't have them, you got to put them in place ASAP, that they will get you into a place where you're a lot happier and a lot more legally protected for your business or for your clients' businesses, for any other business lawyers here. So the 5 ones we're going to go over are the bylaws or operating agreement, your customer service agreement, your employee agreement or employment agreement, your business plan, and your estate plan / exit strategy. Full disclosure now and full disclosure later, I am not an estate planning attorney. I am not a asset protection attorney. I don't play one on TV. I don't pretend to be one, but we'll talk about why every business needs those and why I can give you some information about them. But with that, let's go right into it. Bylaws, operating agreement, some states will call these different things. Depending upon your legal entity, it'll be a different name. But basically, we're looking for that overarching agreement that governs your business, whether it's your law firm or otherwise. And the important part about that is by having that agreement in place, you know what everybody's role is, what your business really does. If you have other partners in the business, if you've got money that you're funded by some other company, if you're going to end up selling shares of stock and take your business public, you have to have all that stuff here so that everybody knows what their rights and responsibilities are as it goes forward. The thing that I tell people is if you don't have a good operating agreement, it's like sitting down and playing Monopoly without everybody knowing the same rules. And if you've ever played Monopoly and you've lost friends and family who no longer love you because of how you play Monopoly, usually it's because of the stuff that we're talking about here, not everybody being on the same page, not everybody knowing the same rules. The cool part about contracts are you can agree to almost everything. Like as long as it's not illegal, you can agree to it. So we have seen operating agreements where somebody put in all the money, but they're not going to operate it at all. They are just the silent partner, and they get 50% of it for funding everything. The person operating it put in $0. They get the other 50%. We've seen ones where family has some interest, so that 1% to everybody's spouses, so they get an easier time doing owner benefit and retirement. You can have somebody who operates the business 1 month, and then the other person operates the next month. We did something for two brothers who ran a company where they switched off. I think it was every 60 days, where literally one of them would be there for 60 days running it, and then they would go on 60 days of vacation, and the other one would do it. And it was so cool, and it worked really well for them. But the biggest thing is that was in the operating agreement. So you can agree to almost everything. If you're bringing in new partners, even if it's with your spouse, you want to have the agreement. An operating agreement is like a gun or a condom or anything else. It's better to have it and not need it than need it and not have it. You don't actually have to follow the operating agreement as long as everybody is on the same page. But when you have those moments where you're not, where there is a problem, where somebody isn't doing what they're supposed to do, having that gives you that sword and gives you that shield to make sure that they are back in place and doing what they need to do. Even if it's just you, then you may not need this. If it's just you and your spouse, if it's just a family business, I would still have one. It's still a lot nicer to have it and not need it and be totally fine with your spouse and never get divorced, or your parents or your kid or whomever the other part is. But if you ever want to bring in a new partner, if you ever want to sell the business, which we'll get to at the end, it's going to be a lot easier if you have this operating agreement in place, so that everybody knows what everybody's supposed to do, so that we're outlining everything with the business and who's doing what and what the business does. And then a lot of times you'll need that document, especially with everything going on recently for the PPP loan and the EIDL, the operating agreement, the bylaws, something along those lines was a requirement for some of the banks and certainly for the EIDL loan. So we definitely put together quite a few operating agreements super quickly for some of our clients. For those, it was a lot easier for the ones who already had it, because the last thing you want to do is have to put something together ASAP in an emergency situation. But unfortunately, that's where a lot of people found themselves.
So Jordan, what are sort of like the outline key components that make bylaws, or an operating agreement? Like how would you define a sort of status minimum for these agreements?
So the short answer is, it is the document that creates your company in whatever legal entity that's going to happen. The longer answer is, it's going to depend upon your state. So states will have some different rules for certain things that you can do. For lawyers in Florida, you can be a PA, you can be a PLLC, and those things will have different requirements on them. They'll cost different amounts to file every year. They'll cost different amounts to create. So you really have to research your state stuff, but ultimately that is the document that makes your business into a legal entity. And then ideally it will also outline what you're going to do, what the business does, what your role is, what the other people's role is, where you're going to get money from, etc.
Okay, and when you say almost anything, what are some of the things that sort of scenarios that have been presented to you where you've had to say, actually, no?
So this is a great one. This is a part of it. Well, this is a true story, ultimately. So you cannot agree to anything that is illegal. So you cannot create a drug selling ring as its own company. However, the IRS does actually have a part where you can disclose the money that you bring in from illegal activity that you are supposed to disclose to the IRS. So that is an example of something that the government would love to tax you for, even though it's illegal, even though you couldn't actually create an organization that does it. So, money laundering, drug sales, a robbery ring, anything along those lines. You can't agree to anything that's illegal, but the IRS does want you to disclose ill-gotten gains on your taxes.
So in the state of Florida, the rules are more or less sort of strict and demanding for people who are looking to incorporate a business?
So, I don't know, because I only practice law in Florida, so I can't tell you how it compares to the other states. I can tell you Florida will let you do pass-through entities. You don't even need a tax ID number. You can just get a federal one from Florida, and it's super cheap. So we do have some easy ways to do it, but the businesses that do that, it's really, you can't bring on a partner. You can't sell stock. You can't bring on equity from other people. You can't take, a loan in exchange for ownership stakes. So there's a bunch of different things that you have to figure out. I would say if you're not a business attorney, you want to sit down with one in your state to come up with your formation documents, because it's a lot more expensive to fix it later. Because if you get sued and you don't have the right entity in place, then it's going to be passed through. There's no corporate veil for them to pierce. They can come after you for your personal stuff. You know, I've talked to other lawyers that didn't even create a PA, which in the state of Florida, there's companies that will do it for free, and then it's like $200 a year. And they were very, very wealthy and running, you know, any potential malpractice without any protection from their business. So for, you know, a couple $100 a year, they were not set up correctly.
Okay, and if you have the need for, based on your business, you know, any sort of malpractice insurance, that relies upon you having bylaws and an operating agreement as well? So one relies on the other, one requires the other?
For the most part, yes. It's certainly, I mean, you look at the standpoint of insurance, and so like your personal insurance protects you personally, your malpractice will protect you acting as an attorney. But if you have a firm, you can protect the firm. If you don't, then you run the risk of everything being touched if you get sued for malpractice.
Right. No, absolutely. Especially important if you're bringing on staff and other partners. So what if, you know, let's talk about another scenario here. There's a lot of, you know, law firm owners like you who've created other entities. You know, you've got LegalEase Marketing, you have a podcast. You know, maybe these are sort of part of the same business or even spin-offs of one business. How do you know when is the appropriate time for maybe a consulting arm or a marketing agency? You've been doing something a little bit, helping friends on the side, and it turns into a real revenue stream. How do you determine, and maybe it's actually the bylaws itself that guide whether or not that's within the scope of the business you're currently operating, or you need a new operating agreement?
So the best example along the lines of what you're talking about is sport agents. So for the longest time, every sport agent was an attorney. And then because of the way of solicitation rules, some of them went away from it. So what the Florida bar and other bars, some other bars put forward was you can have, if you're acting as an attorney, and if you're not, you have different ethics rules. And my position is don't ever put yourself in that position. Do one entity that is a law firm, do one entity that is not. So if you're running a title company and you have title agents that are getting fee sharing, the Florida bar says, yes, you can do that because it's work that doesn't have to come from a lawyer. But my standpoint is for a couple $100 a year, I would make my own title company with title agents getting a cut that would be separate from the law firm. So that's the way that I personally consider it, is from an ethics standpoint, that I only practice law. Jordan Law only practices law. I only practice law as Jordan Law. I market as LegalEase. You know, the podcast we don't monetize in any way, shape, or form. But anything else that I do, I mean, our office building, that's a separate entity. That's not the law firm, even though the law firm works there or is rented there, etc. So from a lawyer perspective, my opinion is just practice law in one entity that is a law firm and come up with at least another entity for the non-law stuff.
Okay. And when it comes to the podcast, let's say that you have quite a bit of IP there, right? I mean, you have quite a bit of, you know, assets from all these recordings. And would that be something that is then just governed under, you know, your law firm as it's relevant to that, or under LegalEase Marketing as it's relevant to that?
That's a really good question. You know, I think from my standpoint, if I went to, like, if you're going to trademark something that could go under multiple entities, think about the one that you want that value to be attached to. As lawyers, for so much, like, we are the product. You know, I try to push a team mentality because I don't do legal work. I don't want people to hire me. But at the end of the day, a lot of people are looking for me or the other attorneys on their personal brand. So that's something that I would definitely think about. We'll get to it at the end about exit planning and exit strategy. You know, if you've got that side hustle that's going to be your next step, or if that's going to be part of your retirement, then I would figure out if you want that to be something that gets sold with your firm or with another entity, or you want to keep it long-term, because ultimately the more you get everything mixed together, the harder you're going to have to unspool things to sell off this piece, to sell off that piece, to brand this, to, you know, whatever the next step will be.
Branding and naming conventions. I mean, I'm really glad that you brought that up because I think there is, there's often a lot of questions around how to approach that. Do you approach it with your name? That's where the business is coming in from, your connections, whether a lot of them are personal, but then there's also the matter of expansion because you get more and more distant from the growth and marketing of the company as you expand, bring on partners, bring on associates, whatever, if you're in a law firm or in another type of business. So that's often something that we have our clients discuss at Smith.ai, saying, you know, because we are sort of the keystone of the business and in touch with a lot of their different systems. I have a lot of people who come to me personally and say, look, you know, you see small businesses day in and day out. Should I maintain the, you know, first and last name plus law firm, or should I try for my last name because my family is expanding with me, or something location based or something thematic based on your practice area? You know, oftentimes you want something that is a signifier of quality attached to a last name, for example, but it doesn't necessarily have your full name, which can then allow for a little bit of a balance and room for expansion. So that's something that's come up. Also, Jordan, there's a question here, you know, from another attorney who says, you know, how do you, I guess from both the attorney who might take on this work themselves, you know, such as that you're doing with the preparing these business documents, and then also the consumer side who's not an attorney but looking for these, how are they priced? You know, is it value-based, flat fee, hourly? What can a business law attorney maybe in another state think about if they're going to get into this practice of law? And then from the consumer business owner standpoint, what could they expect to pay, you know, keeping in mind, obviously, it may change based on market rates across the board. How is pricing sort of approached with business documents in general?
So whoever asked this, fantastic question. Ultimately, there are three ways to answer this question. The first one is you come up with a flat fee. I mean, realistically, when you do these are transactional enough, you'll figure out your hourly time. So like, let's say, you know, our hourly rate is usually about $400 an hour. For us to do one of these agreements, we look at it taking between 3 and 4 hours between sitting down with a client, confirming the documents, having them drafted by the paralegal, sending them back for review, etc. So for us, it'll be about $1,500 to do this. So you can do it hourly rate, or you can do it flat fee based upon knowing how many hours it takes. The more you have it automated, the more help you have from a paralegal, the more you can outsource it, the less it actually has to be you. It might change those numbers a little bit. But the third way to do this, and the one that we've started doing over the last since COVID, we started doing a monthly subscription-based service for business owners. So they pay a fee for us per month. And for that, they're getting a certain number of documents done every month over the course of a year, or reviewed or edited or something like that. So that's something that I found a lot of business owners like, because for those of you that do business law with COVID, my discussion with clients, or I guess really the social media push that we have on updates, changes every week, every hour, every county. We're in phase 1, we're in phase 2. Our South Florida people, you know, their restaurants just opened 2 weeks ago. In Orlando, it's been open a lot longer, but our playgrounds still aren't open. And, you know, the theme parks changing everything. So that's been something that a lot of business owners have liked, to just be able to pick up the phone and call and know they can talk to an attorney for an hour a month or 2 hours a month as everything goes crazy and changes. If you're going to do that, I think either writing the operating agreement or editing it and making sure it's 100% correct would be one of the key functions that I would make sure you do as part of that long-term proactive relationship with a client.
That makes a lot of sense. Also to say, you know, even if you have a monthly retainer or subscription model, you could also have a ramp up and sustain model where you have a few initial deliverables up front that are needed based on the client's needs, and then on an ongoing basis there's more of a maintenance, or you hit certain milestones that signify it's time for another relevant document.
Yep, 100%.
Great. Okay, well, we can move on from this document and go on to the next one.
All right, so the next one, customer service agreement, retainer agreement, engagement agreement, whatever you want to call it from the attorney side. I cannot begin to tell you how dumbfounded I am talking with people that run a $3 to $5 million gross annual revenue business, who agree to high 5 and low 6-figure vendor agreements without anything written down. Like, it boggles my mind, but it happens. Like, I have talked to people that are way more successful than me from at least a financial standpoint that don't have a customer service agreement. So if you're selling a product, it's probably pretty easy. Most of the time you're getting a receipt. That's the customer service agreement. You have given them, $15. You have bought this shirt from Target or whatever it is. If there's some sort of long-term, where they're, oh my God, I can't think of the word now, where they're guaranteeing it for a certain amount of time, you get the built-in protection.
Warranty.
There we go. Thank you. So if they're warrantying it, then there may be something written there for the product. But for the most part, you have exchanged money for a product that you have right there. But for a service, you're giving somebody money or something else of value for the promise of future work. You don't have that quick exchange. And so for a service-based customer service agreement, for lack of the same word over and over again, it's important for you to talk about what you're actually doing. What is the scope of work? What is included and not included? And then you also have to talk about, when's it going to be done? What's the turnaround time? Are there certain check marks? How are people paying? What involvement do you have after the work is turned over? Maddy, like you mentioned about, the maintenance plan or something along those lines. How are they paying you? Is it all up front? Is it half up front and half at the end? Is it staggered? Is it installments over that time frame? What guarantee do you have for a work? As lawyers, obviously, we can't guarantee results or an outcome, but if you have any sort of guarantees beneath that you can make, that's something you have to have in that customer service agreement. And you can use pretty much the same agreement over and over again. You just swap out scope of work or type of case. You swap out amount that they're paying. It's a flat fee, it's an hourly, it's a half up front, it's a quarter up front, whatever it is. And just like the bylaws, if everybody's in agreement with the customer service agreement, if everybody doesn't care about how it's going out, it's totally fine. If you have that client that magically pays you faster than they're supposed to, and everyone's okay with it, great. For any of you that do, please message me so we can talk more about how you've made that happen.
I'll host you for a webinar, exactly.
Yeah, right. The flip side of it is when people aren't doing it, it's really helpful from your perspective to have that to beat over somebody's head. Also, the turnaround time, that is a huge thing. And that's something that you may want to consider putting in your engagement agreements for the client. Like, we will have this flat fee project to you for your review within 2 weeks. And then whenever you approve it, we'll have it to you, done 2 weeks after that, something along those lines. You might actually be able to use that as a selling point for you, because think about, the average person doesn't know an attorney. The average person is coming to you for engagement or your business to hire you for that service. You can put things in the contract for their benefit that give you the sales pitch. You can guarantee your work in certain ways that other people don't. You can make the turnaround time. We've worked with some criminal attorneys for LegalEase that do the actual case, and then they get the mugshots, or they try to get the mugshots taken down. They cover the if there's a violation of probation or the early termination or the sealing all in one thing. And so their scope of work is really set out to those things. And obviously they have, like, if you stop making your payments, we don't have to do the rest of the things for you, to give the client the carrot and the stick. But think about what agreements you want in both directions. If your client has to give you a response back in a certain time frame, make sure that's in the contract just as much as making sure your end of it is in that customer service agreement.
Yeah, I think one thing that we also see here, I'm really glad that you brought up the point, Jordan, about what is the client's end of the bargain, right? What are you holding your clients to? That a lot of this is contingent and hinging on the client responding promptly to your questions to do the work for them. And there's also a lot of boundary setting that can be done here. How are you going to set proper guidelines for your client's behavior to not expect to bother you at 3 a.m. to say, hey, you asked for a prompt response to your questions, and here I am. This is the time that I have. I need to talk to you right now, or matters that are urgent. I mean, we've seen some of our clients even define, through Smith.ai, like, this is my definition of an urgent scenario. Does that match up with what the customer service agreement states is a matter of an urgent need where the business owner is going to go out of their way to respond beyond the normal sort of, response time frame. So that's
Yeah,
something that may also be a factor. Go ahead, Jordan.
the biggest one I've had, I don't remember who I was talking to, but I was talking to a family law attorney about this, and they had mentioned how, most of the time there's the switch over of the kids Friday afternoon after work. And so they have a thing in their service agreement that is like, look, a half an hour window on whatever that turnaround time is not an emergency. At 35 minutes, great, call away, we'll have the motion ready to go, but the case law in our state says this or whatever it was along those lines. So they're like, I don't get calls until 6:30 on Friday instead of at 6 o'clock. But, for better or worse, I don't know if that was the intended consequence or not.
Yeah, I mean, we have clients who are in finance, in IT. I mean, even in website development and design, some person may feel something is urgent, and as a professional, as an expert, that it's urgent or not, and the impact on the business that it will have. I mean, even on the legal side of things, there are practice areas that may demand time in court. There's litigation, and then there's areas where that's not even going to come into play, where you can more sort of predictably expect what the terms will be of the agreement, what the scenarios will be that are presented to you in working with clients, and you can sort of provide yourself the extension as you need to account for those unknowns, the unknown. You want to reduce those and say, in the event of this, there may be an addendum, there may be a revision, that these scenarios often incur additional costs, right? So you're upfront setting expectations. And one of the things that's sort of scary for some business owners that we see, but as we have had a lot of conversations at so many events before COVID, we would often hear, do I sort of sneak in the agreement, or am I super upfront and do I review the agreement sort of line by line with my potential clients and make sure that they read it? We've all signed up for something online where they give you the agreement, you run down, you scroll your mouse as fast as you can, and then you click agree because you're signing up for your Yahoo Fantasy Sports thing and you're not going to have any terms of negotiation, right? But then there's actually something that's much more one-to-one. Jordan, what do you recommend? Do you recommend sort of having a meeting to closely align and review this and make sure everything is understood so that potentially doesn't come back later, or just sort of provide the link to this and make sure that they saw it and confirm in some way?
I am unaware of a situation in which somebody was better off trying to sneak things past their client that the client then figured out later.
I agree.
For us, I mean, look, let me give you the great lawyer answer. There was a judge I was in front of that had the best line. He said, lawyers have the ability to take a 10-minute argument and distill it to its 3-hour essence. So having tried to make the shortest contract possible for clients, I think I have a 4 or 5 page contract.
Okay.
And that was as short as I felt like I could make it to cover everything that we had to do. And is it perfect? No. Have I had to use it in court yet, though? No. Have I had anybody tell me they didn't hire me because my contract was overly wordy or too long? No. So there's risk to happen everywhere. But I think that I'm trying to build a business for the next 20 or 30 years. And a lot of times that is based upon customer service with my clients and customers, because I don't want to hide anything from them. So I get a kick out of going over it, and to go back to, guarantees that you have it. I mean, on LegalEase, I like going through our contract and explaining like, look, make sure you read this part carefully here where like you own everything we're doing for you, as opposed to your prior company that you don't own anything that you spent all this money on.
Yes. It could be a competitive advantage. That's a huge, huge point right here, especially if anyone's thinking about redoing their website or engaging with a designer marketing agency. We see that so often, that you have to make sure where the ownership lies. And that is a massive advantage. In fact, it's binary yes or no on the agreement, as far as I'm ever concerned. When I run marketing for Smith.ai, like, you have to own the assets that you're working on together.
Yep. I mean, I'm on, look, don't get me wrong. I had it happen to me, which is why I don't do it to other people. So
Right.
Don't be ashamed if you're in that boat, because trust me, I was the captain of that ship for a long time.
And if you don't know, don't wait to ask,
Right.
because that's something that would need to be resolved. So let's go to the next one, and I'll keep an eye on any questions as we process, Jordan's advice here. We can always go back, but let's keep moving forward.
All right. So employee agreements or employment agreements. There's a show online that has been making the rounds on a lot of the lawyer groups called Undercover Billionaire, not to be confused with Undercover Boss, where a guy gets 90 days, gets $100 and 90 days to build $1 million business. And I'm not going to spoil any of it, but he gets a bunch of people to do a bunch of stuff for him for free. And the entire time I'm watching it, I'm like, if these people called me, I would advise them to like turn around and run. And it's TV on the Discovery Channel, so you can guess that it ends somewhat happy for most of the people. But you have to have employment agreements, and this is something that like I am just as serious about these if you are the employee as I am if you are the employer. Like, this is for the benefit of everybody. This is a written contract between the employee and the employer that goes over pay, benefits, hours, the work you want them to do. I think all this boils down to it's better to have something in writing and signed by both parties and not need it than it is to not have it and do need it. So there are obviously, when we're drafting employment agreements from the employer side, there are certain things that we have in there, like non-disclosure agreements, like business processes they can't disclose, like non-compete agreements. There's a lot of things that you can have to put in there to protect the business. But as an employee, I would tell you to be just as interested in having a written agreement, because random things are going to happen. And we had 40 million people get terminated under COVID. It'd be really nice for those who had employment agreements that gave them some sort of protection or some sort of an awareness of when they could or couldn't get fired, as opposed to everybody who just went into work on Friday and at 3:30 were told they no longer had a job, which has happened and will happen to millions more people. So I like these from both sides. Obviously, we're going to sway them in the employer's favor when that's the one hiring us, or we're going to sway them in the employee's favor when that's the one hiring us. But I think that everybody should have an employment agreement ready to go. You may have some employees not on it. Like, don't get me wrong, I have interns that don't sign the same agreement with us as other people, that I just have like, you cannot disclose our employment information to, or our client information to anybody else, no matter what, etc. But a long-term employment agreement is something you want for any long-term employees. It is so much more helpful. I have saved businesses hundreds of thousands of dollars because they were able to do stuff because there was a signed agreement that they would not have otherwise been able to do. And I've been able to get employees, quite a bit of money as well, because they got screwed over by a business that violated their own agreement. But thankfully, they had a leg to stand on now that they wouldn't have in an at-will state.
Yeah, there's a lot here. I think I've managed pretty large teams, and obviously, as you mentioned, Jordan, there's a difference between different roles and what that employment looks like and the agreements that are signed. One thing that we always do, there's an NDA, whether you are a receptionist, chat agent, or senior executive leadership at Smith.ai. There's also a non-compete is fairly normal, and also information sort of ownership, like and IP ownership. So anything that you're creating as an employee of the company is the company's owned work product, right? So your work product is the company's work product, unless you are an outside contractor, right? In which case you're not being told how to do your job, because that's the nature of being an employee. It's a lot of guidance there. So that's another thing to be careful about. But one thing that I'll also mention with respect to small businesses is that if you are doing things like taking credit card payments over the phone, or you have assistants who do that, one of the reasons why we have the receptionist sign additional agreements is we have a confidential sort of financial non-disclosure, separate agreement to just the regular non-disclosure, but you're dealing with sensitive financial information. You're not processing, but taking, credit card information over the phone, for example. That is particularly sensitive, and we actually write that in separately. So consider like the actual job duties, the amount of work product that's created versus just following processes and procedures. that's also going to determine, what agreements, not to mention the state laws. If you're in a state where you could have someone sign a non-compete, going back to Jordan's original statement around what's enforceable, non-competes work only insofar as you're not blocking your past employee from making a living in their field of expertise, right? So
Right.
how strict are those? Are they able to make a living if they do part ways with you? That's something to consider. Like, you want it to be strict, but not so strict that it really is off-putting.
Yeah, and so in Florida, I want to say it's blanket, but I'll leave open the chance that I'm wrong. For the most part, you can't non-compete an attorney. You can't prevent them from being an attorney. For other positions, you may have to limit it in timeline. You may have to limit it in scope of business they can work for. You may have to limit it in geographic area.
Mm-hmm.
But it just, and it's one of those things that ends up breeding a lot of litigation, because you're going to have that opportunity where that person gets poached because they're so good at their job. And it's something that you have as the employer, and it's something that you have as the employee that's there to, limit what can happen in both directions. Well, I guess in non-compete, it's going to limit what the employee can do. So it's pretty interesting to see how these things get played out. But to circle back to what you said, Maddy, without going into too much detail, we represented a doctor or a doctor's office that had somebody that literally just started stealing credit card information for everybody. Or they were stealing, no, sorry, not credit card information. They were stealing their health insurance information and trying to commit health insurance fraud. And so thankfully, there was a written policy in place that they signed about what they were supposed to do with the HIPAA information, all that data that's not supposed to happen. They had run a background check on this person. They had no prior theft convictions. They had no criminal history. They had nothing along those lines. And that was potentially millions of dollars of exposure for those HIPAA violations that were able to be minimized, a 1,000 times over, because of having, really one document in place that the employee had signed with a policy about not disclosing this information.
Right. And I think that brings up a really good point of, you can sign an agreement, to the end of the earth. You can have them sign 20 agreements, but if you don't enforce it, if you don't have a whistleblower policy, if you don't have sort of processes and systems for flagging and monitoring, your employees, and making sure that you can enforce, these agreements, it doesn't matter as much, So make sure that in that scenario you mentioned, Jordan, how does that, sort of see the light of day? Well, is it a whistleblower? Is it a system flag, that a record's been open or exposed for too long? Is it, what are these systems that can be put in place to make sure that these agreements are enforced to the best of your ability?
There's all sorts of things. And the one thing that I think a lot of businesses don't do is training on these things. Having a lawyer come in, or even the owner of the business, talking for an hour on, look, we have to follow this. These are the Florida bar ethics rules, or these are the HIPAA requirements that govern our office, or any of the government agencies like that oversee it. Heck, I've talked to realtors who do presentations to the other realtors about the DBPR and the rules that they have to follow. And a lot of times that ends up minimizing the liability of the business, because they can say that somebody, knew this or should have known it because they were trained on it, as opposed to just, we buried it in a 25-page contract or something along those lines.
So that brings up a good point. Where oftentimes we see in agreements that there's a signature on every page, there's initials, there's signatures at the very end of the agreement with multiple clauses. Like, how do you sort of determine what's necessary there and where to sign, Jordan? It seems basic, but I have no idea.
So I like e-signature, to be honest, better than real signatures, because it can confirm that this is the document that was signed with all those pages. Mm-hmm. There's no argument that, like, oh, I didn't sign that one later and you forged my signature here, or there wasn't a page 7 when I originally signed it, or something mm-hmm. along those lines, which I think a lot of people, I wouldn't be surprised if a lot of people disagree with me. But as a former evidence nerd and now a business owner, I don't want to say I prefer e-signature overall, but in that situation like you're talking about, I like an e-signature because we can show digitally this was the document, which obviously people can argue they're not the one who signed it. So I want some sort of in-person clarification or whatnot. So maybe we get them, we have somebody else notarize the e-signature, or we have somebody notarize the contract to make sure that it's all there and that we've got a witness later. But you bring up a good point that we have had issues, and we're going to talk about estate planning briefly. I'm sure you see it a lot more there for wills, where you're going to get so much litigation that somebody says, well, that's not the will that they signed, or that wasn't correct, or that's not what it said when they signed it. And so there's a lot of money that can be spent when you're not sure if somebody actually read something or signed something or saw it, or if it was in there.
Yeah, that's a great point. And actually, it's an interesting idea to see the e-signature tools as a advantage, a unique sort of advantage here, because oftentimes they're seen as sort of the secondary approach. But I see your point. Certainly better than sitting around a boardroom with 10 people signing each page. So even if that's not even possible right now, when it was. So
right.
Let's go to the next slide.
All right, so here we're going. The last two, well, I guess we're going to go outside of my legal expertise, or at least outside of the legal basis. So a business plan. This is one of my all-time favorite quotes. Failing to plan is planning to fail. And I say that as somebody who did not plan for like 3 years and just failed for 3 years. I learned so much from that failure. It all started with the fact that I didn't plan. So now I'm anal about it, and I plan probably more than I should, and I fail a lot less, which I still fail plenty, but I fail in a more controlled manner, in a more learning manner, in a less frequent manner, in a less expensive manner than I do now. And so a business plan, this is one that's really good to have. It can be super simple. I mean, literally, my kid's 2.5, and I'm trying to instill in him like entrepreneurship over the next couple of years. And so like he'll have a lemonade stand with a business plan just to get it in, and it'll be colored in crayon, and it'll be 1 page long, and it'll be like lemons plus sugar plus water equals delicious happy people, or something like that. But you can get really complicated with business plans. I mean, you can get into business plans. I'm unaware of anybody being 1,000 pages, but I'm aware of ones being 200, 250 pages that are overview of the business, summary, accomplishments, specifics of the industry, profitability, market, etc. This is one that's probably a little bit more important for non-law firms, just because a good business plan and following through on a good business plan makes it a lot easier for a business to be sold, and law firms get sold in a really different manner than, let's call it, normal businesses. But a business plan is something that all businesses should have, even if it's hand scribbled on a notepad like this one, or even if it's in Google Drive, or if it's in your attorney's, if your attorney has it saved in a safe somewhere, something along those lines. Have some semblance of a business plan. It'll have marketing stuff in it. One of the things that now that we push for people is a brand book. So like people will have their specific colors in it. So the hexadecimal, I don't know, that's somebody smarter than me goes through that stuff, has the actual color that matches. Like the blue that you're looking at here is the blue that's on all of my slideshows, because somebody picked this blue for our thing, and it goes consistently across all of them. Things like that can all make up the business plan. It can be as complicated as you want, or it can be as simple as you want, but have it, and have one that you can follow, and you can edit it whenever you want, and you can, set goals to hit those numbers or not, and if you don't, you can change it. But the more that you have that plan and the more you follow it, the better shot you have at being successful.
I think also like an important thing to note here is when you bring on staff, it's also a really helpful way of aligning your staff to your business goals, because everything is very clearly laid out. We've talked about all these agreements, and the, operating, bylaws, but also what is your playbook day to day? How are you setting goals? How does that align to your business plan? That's something where you really want that buy-in from that staff, from any contractors maybe who you're working with. How does this align to your positioning, your product market fit? That's oftentimes much easier to define for long established industries like legal, because we know what the product is and how it fits into the consumer or business needs. But we do see very often that there are even things like your systems and communications plans in your business plan. How do your CRM, your intake program, the questionnaire that you ask clients, things like that can be in your business plan. And that then gets into the transferable assets like that go into, all right, you have this operations manual, you have a disaster plan, even you have, all of these day-to-day and also one-off scenarios. That goes into sort of what you're going to talk about next, which is an exit strategy and what the value is of your business without you potentially even there.
Well, if we have any lawyers on this in Arizona or Utah or every other state that's about to do the same rules to allow non-attorney ownership, you better have a business plan yesterday, because the amount of potential outside money and the changes coming with the legal industry in your states, you're going to be the guinea pigs for this across the board. But I think, look, two things are going to happen. Either lawyers are going to be able to figure out how to make their firms run more efficiently and more effectively and more like a business, or Google's going to own a law firm that runs across the country and crushes all of us. But I guarantee you, whatever business ends up in those is going to have a plan, and it's going to be a good one that they execute.
Absolutely.
So with that, not to end on a dour note, to end on a happy note, an estate plan, an exit strategy. So again, I am not an estate planning attorney. I am not an asset protection attorney. That is not my thing. I am not numbers enough or smart enough for those things. So you need to have them from an expert who really knows it. But the way that that flows into the business is you have to have an exit strategy. So can your business run without you? Thankfully, as of literally last Thursday, I have been told, although I have not tested, that my law firm can run without me. We'll see. I will definitely take them up on the offer for me to be gone more frequently. We spend a lot of time building a business that we want to be essential, or I should say, building a business we want to be essential in, but that's not a business, that's a job. Building a business means you are not essential in it. And so having that strategy in place from day 1 or day 90 or day 3000 will help you make the decisions that you need to make, like Maddy talked about earlier, to get that in place, to follow through on that, to be able to get out, to know what, for me, I talk about it as your definition of success. We want to be moving towards what we think would be the success for us. So, you want to have this in place before you're forcibly removed from your business, whether that's financial, whether that's unfortunately dying, it will happen to all of us, whether that's a change in the market, whether that's COVID happening again and longer and worse, whether that's Google or a non-lawyer opening up the largest law firm in the history of time in your state, because now non-lawyers can own them in certain states. That might include having an insurance policy for the owners. That's one of my favorite things to do. If we have businesses owned by non-spouses, we have the business pay for life insurance for each of the owners. And if they pass away, the other owner gets their ownership and the family gets the life insurance policy, because that way the family has money from it. It has the retirement need of the business that's supposed to be there without protracted litigation to make sure that it's lined up. The more the owner does, the more training and hiccups there will be to get somebody new settled into those roles. And lawyers, this one's going to speak to you all. The average solo attorney makes $40,000 to $60,000 a year, but has over $100,000 in debt. So the less the owner pays themselves, the more they're going to have to pay to replace them by somebody making actual fair market value. So you have to have that strategy in place today. Even if you can't afford it, even if it's not something that can happen tomorrow, having that plan will let you make the decisions to get closer to it, will put you in a position to retire and run the business, and have the business as passive income, or be able to sell the business and use that as your retirement, as opposed to constantly being stuck in your business.
Yeah, I think that this is something that oftentimes is not given a lot of dedicated time to put together until you're already in that situation. And often the problem with being in that situation and making all these decisions, one, life insurance is something that you're going to plan ahead for, obviously. But, writing all these documents out, often I find, I'm sure Jordan, you also find that, if you're putting together processes and procedures and drawing all of that out of your head and your team's heads collectively, there's a bit of like a digestion period, you know, like you need to look at it again, like ask for review and make sure nothing is missing. It's not the sort of like wham, bam, knock it out in a single meeting sort of thing. You know, it's going to be collected over time. It's going to be reviewed. There are multiple stakeholders. So as you're putting together, like, you know, all of the assets and values and everything that's sort of essential to your business, also ask yourself, like, you know, if something were to happen, and even something as simple as I need to teach my kids and they're being homeschooled right now instead of going to school, these are things that we may not have realized are a huge time consuming and extremely important aspect of the day that now you are committed to doing, that takes away time, because unlike money, you can't get a loan for more hours in the day. So what are the draws on your time, right? And one of the things that you can do, if you can delegate out, you know, your work, you can have, you know, that time for your family, for taking care of even older generations. Now that people are living longer, you know, we've got a sort of middle generation that has children and aging parents. So you have even more draws on your time. Making the decisions that allow you to choose your path in life, whether or not you're a business owner, being able to make the decision is the key, right? Just because you have these things set up and your business doesn't need you, doesn't mean that you are, you know, sort of not necessary or not wanted at the table anymore. And I think that's a really important thing to distinguish. It's that there is the freedom of choice and the ability to not lose out on the business side of things if you do have to or choose to educate your children who are home now. And that's sort of the safety procedure that you're doing. That's a personal choice. We see that very often right now. And I think that it's really, really important that you see the delegation and outsourcing and systems that you set up as furthering your ability to make choices and not be stuck with the responsibility on just you or a core couple people, because we see that so often. And when you want to go ahead and make a choice, there is, I would argue, more work in that changeover period than there was even if you're just going to do it yourself. So that's actually, I mean, think about it. Anytime you've trained a new person, I'm feeling this way because I have a new person coming on next week. I know I'm going to basically clear my schedule to train this person. And there's a short-term loss in my availability for a long-term gain in this person taking on responsibilities that I currently bear. But if I don't plan ahead for that, then I'm not going to ever commit that time and have that benefit of where do I spend my time? Well, not on those things because someone else can do it. Maybe I'm free. Maybe I choose to do things that are higher level tasks that only I can do as a member of the leadership team, or in your cases, as an owner.
Yeah, and you will look at the very least, having this exit strategy and being non-essential allows you to take a break, whether that's a day a week, whether that's a year of, you know, teaching your kid, whether that's a week and a half vacation, whatever it is, you know, it allows you to take a break. But what Maddy said is so true. You know, the more you have these in place, the more you have all those things lined up, it's a lot harder in that moment. It takes a lot more time in that moment, but the long-term gain, the long-term benefit is so worth it. I mean, it's probably been a 3-year process for me to get to being unessential on a firm that I've run for 5 years. And it really took me sitting there $200,000 in debt, deciding, do I have to close and go find a real job, or can I keep running my own business? And realizing I could, but I couldn't keep doing it the way that I was doing it, to put systems in place, to put plans in place, to put processes in place. And then, you know, when COVID hits, you know, a situation like this, knock on wood, we actually were able to bring on 3 new staff members during it because they were people that had backgrounds and experiences that there was no freaking way they were going to come work for me during a normal time frame. But we had, you know, enough in reserves and were busy enough and had a plan in place that we could bring on some people while it was a little bit, you know, a little bit slower, to let them get up to speed, to let them actually sit down with everybody else, to get them to learn how we wanted them to do it, to now be positioned with 30% more of a workforce ready to go when things do get back to normal or whatever that looks like, because we had systems in place and processes and a good team. And me being not essential, let me do some of the onboarding. With the first person became making sure that onboarding was its own system so that they could do it for the next person. And just, it's hard work. It takes time, and it's harder than just doing it the way you've always been doing it. But you'll always be stuck doing it that way if you don't make the change.
That's exactly right. The time to change is right now, especially when there is less pressure, and maybe you have a little bit of a slowdown or a gap in business, and this is the time when you can focus on your systems. I mean, and even if you don't have, a ton of resources, what you can invest in is your expertise and in your team who are there. When you don't have a lot of money, focus on what you do have, which may be time depending on your situation. It may be your staff's time if you're not as busy. How can they help you document a lot of processes? This isn't just you. But I will also reference the other webinar that we did together, Jordan, on delegating down to a 3-day work week, which I think would be relevant here. And I will, in my follow-up email and also in the notes on the YouTube video for the recording, share that link. And I highly encourage you to, reach out to Jordan. If you're interested in learning more about Smith.ai, we do have a special code for you, which is EASE, EASE 100, that's 100, EASE 100, which will get you $100 off your first month of receptionist or chat services from Smith.ai. We run 24/7 so that you can hopefully allow more time for yourself to put these processes in place, have discussions internally or with your attorney, depending on the nature of your business, so that you can, really shore up and have a stable foundation on which to grow, on which to, sell your business if that ever comes into play, and just have the confidence that you have the structure in place to take your business where it needs to go and to back up the work that you're doing for your clients, which is another really critical component here. Jordan, is there any last word that you'd like to share with us?
Yeah, I want to give you guys a shout out. So one, obviously, thank you for having me on. But two, it's one thing for you to say what you just said. It's another thing, let me echo what you just said. A lot of times, look, there is no problem a business has that can't be solved with more money. If you have more money, you can throw it at every problem. You can hire more people. You can bring in an expert. You can bring in a consultant. You can buy more office space. You can buy better systems, whatever it is along those lines. One of the places, though, that we truly and genuinely find is the easiest thing for our clients to do is bringing on an answering service, because when that client calls or when that customer calls and they want to sign up now, and it's just you, or it's just you and a paralegal, or it's just you and one staff member, it's a lot harder for you to drop everything you have than it is for, one of Smith's great people to go ahead and field that initial call and get it set up in a time where it fits your schedule, which gives you more time to do all these things. So I'm not just here because Maddy said yes. I'm here because I believe in what Smith does and how it really helps people.
Thank you so much, Jordan. I'm putting that means a lot. And, I think that these sessions are so meaningful because we get to share so much expertise on a specific subject that, these conversations may have happened at in-person events, but, we need to bring them up to the surface. And, we're happy at Smith.ai to be able to host them from our experts within our community. And that's just one of the benefits of serving small business owners. So I just shared the code in chat, and I really appreciate your time. Everyone, thank you for joining us. I will send a follow-up email with Jordan's contact information and mine. And I will also put that in the show notes for anyone who's watching the recording. So have a wonderful rest of your day, and I look forward to seeing how we can help you specifically. Feel free to reach out to us. Take care.
Thanks again for having me.
Thanks, Jordan.